is back in session. The court is in session with cause number 23CCCR 2292, case of style the state of Texas versus Kendra Kiara Plowden. Ms. Plowden had previously entered a plea of, she was previously sworn in. She entered a plea of guilty to the information of theft, charging her with theft, with Class B misdemeanor theft. Ms. Plowden acknowledged that she read that her signature, that she recognized all of the documents that was presented before her. These documents was a judge's explanation of rights of defense by an attorney, a waiver of counsel, the misdemeanor plea admonishment, and the trial court certification of defendant's right of appeal. Ms. Plowden stated that she was a citizen of the United States and that she was mentally competent to stand trial, and she did not object to the state's offering state's exhibit number 1. State, could you repeat the offer that you made in this case?
6 months deferred, fine waived, 30 hours community service.
Okay. Now, the state in Ms. Plowden's case offered that Ms. Plowden serve 6 months deferred adjudicated probation. During the 6-month probationary period, Ms. Plowden was not required to pay a fine, which was waived. She, however, was required to pay court costs in the amount of $277, and she was required to pay probation fee of $60 a month, analysis fee of $15 a month, and reimbursement fee of $15. The court asked Ms. Plowden if she could pay the total monthly installments of $148. She stated that if she asked if the court could lower it, the court have an affidavit before it. Ms. Plowden, do you recognize this affidavit of indigence? And on page 2, is this your signature above the line that's out of defendant?
Yes, sir.
Now, before you signed and initialed this document, did you read the document? Did you understand this document? Yeah, is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Ms. Plowden, the court is going to find that you're indigent. Let's see. Now, the court cost of $277 will be converted to community service. It's going to be converted to 22 hours of community service. And the probation fee in this case will be reduced to the statutory minimum of $25 a month. Hold on a minute. And the court will waive the reimbursement fee of $15 a month pursuant to Article 102.018, because the court is finding that you are indigent. That's 0.0185. Yes, let's see. It's Article, Article 102.018. And as I mentioned earlier, let's see, so that comes to a total of it's 25 and 15. This is being waived. Okay, 20. So Ms. Plowden, your probation fee will be $40 a month. Will you be able to pay that?
Yes, sir.
Okay. Now, Ms. Plowden, do you understand the state's offer?
Yes, sir.
You think that the state's offer in your case is fair and just?
Yes, sir.
And do you think it's fair, the adjustments that the court have made with regards to Article 42.15 and Article 102.081 are fair and just?
Yes, sir.
Also, now you also required to perform 30 hours of community service. Now the 30 hours of community service will be in addition to the 22 hours that was converted from the court cost. So it comes to a total of 52 hours of community service. Do you understand that?
Yes, sir.
Okay. Okay, now, Ms. Plum, do you accept the state's offer? Okay, I'll follow the plea bargain agreement that you've entered into with the state. Ms. Plowden, just have a seat, wait for your name to be called, and once your name is called, you'll go to the window and follow the directions of the building. Okay, next case is cause number 23CCCR 2522, case to style the state of Texas versus Alton Guidry Jr. Mr. Guidry, your full name is Alton Guidry Jr. Alton Guidry Jr. Mr. Guidry, would you please raise your right hand? Mr. Guidry, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Guidry, you may put your hand down. Mr. Guidry, I have before me a document that is titled Judge's Explanation of Rights of Defendant's Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant? Or are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Injury. Do you recognize this document? On page 2 of this document, there's a signature above the line that's titled Defendant's Signature. Is this your signature? Mr. Guidry, before you sign and initial these documents, did you read the documents? Did you have someone help you to go over these documents? And did you understand everything that they went over? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Guidry, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is currently on Zoom. The attorney is Mr. Todd LeBlanc. And Mr. LeBlanc will be given information to contact you. And you will also be given information to contact him. Our court coordinator will give you that information. Before she gives you that information, I need to have the bailiff. The bailiff is going to hand you some bond conditions in a minute or two. Mr. Guidry, I'm going to go over these bond conditions with you. Mr. Guidry, the document that you just been handed is titled Standard Bond Conditions in County Court at Law Number 2. I'm going to go over these bond conditions with you. And it states that following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of the defendant named here are ordered subject to the additional conditions. Number 1, the defendant shall not commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition? Condition number 3 states that the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? And condition number 4 does not apply. However, on the next page, condition number 5 does apply, and it states that the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 107 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that? Okay, now, Mr. Guidry, if you violate any one of these bond conditions, your bond can be revoked. And if your bond is revoked, a warrant can be issued for your arrest. Now, Mr. Guidry, this will conclude your case. Please stand in front of please have a seat in that chair by the wall. And once they finish with the paperwork, they're gonna call you to the one. And once you get the paperwork, you're free to go and you have a blessed day. Here you go. Damon Stanford? Yeah. Do we have his paperwork? Okay. Yeah, Damon Stanford?
And there's a Zoom verification right here, Judge, for him to plea.
It's signed by all parties.
Yes, Your Honor.
Jefferson County Court of London is back in session. The court is in session in cause number M329840, case of style of state of Texas versus Damon J. Stanford. Mr. Stanford, is that your full name? Okay, Mr. Stanford, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Stanford, you may put your hand down. Mr. Stanford, how are you doing?
Good, how about yourself?
I'm doing fine, thanks for asking, Mr. Stanford. I have before me on the monitor your attorney, Mr. Todd LeBlanc. Mr. LeBlanc, how are you doing?
Good, Judge. Thanks for asking.
Now, Mr. LeBlanc, do you waive a record in Mr. Stanford's case?
We do, Your Honor.
Also, I have before me a document that is titled Joint Request for Plea and or Sentencing by Video Conference under the Texas Code of Criminal Procedure, Article 27.18. This document allows your attorney to appear by Zoom, and there's a signature from the defendant, Ms. Stanford, is that correct? And your attorney have signed as well as the state, is that correct?
That's correct, Your Honor.
The court is going to approve this document. Mr. Stanford, I have before me a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Damon Jace Stanford, on or about April 29th of 2021, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of criminal mischief. Mr. Stanford, you understand what you've been charged with? And to this charge, Mr. Stanford, how do you plead? Guilty, not guilty, no contest?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty? Mr. Stanford, do you recognize this document?
Sure.
On page 2 of this same document, there's a signature with a set of initials on the line that's checked guilty. Did you place your initials on this document? On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature? And on the next document, that's titled trial court certification, the defendant's right of appeal, you recognize this document. And it's your signature on the line that's titled defendant. At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have before me a document that is titled discovery certification. You recognize this document?
Sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Now, Mr. Stanford, before you signed and initialed all of these documents, did you read the documents?
Yes, sir.
Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
And did your attorney go over these documents with you? And did you understand everything that your attorney? Mr. Stanford, are you a citizen of the United States?
Yes. CF 61.
Any objections to State's
No
Exhibit number
objections, Your
1?
Honor.
No
No
objection.
objections, Your Honor.
State's Exhibit number 1 will be admitted. Mr. LeBlanc, you advised and counseled Mr. Stanford. Is there any evidence that he is currently mentally incompetent to stand trial?
None that I'm aware of, Your Honor.
And Mr. Stanford, your attorney, Mr. LeBlanc, has advised and counseled you. Are you satisfied with his representation? Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Stanford, I will accept your plea of I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
What is the agreement?
For plead guilty, stay is offered 125 days, time served, court costs, tax, and retired.
Okay, Mr. Stanford, the state is offering that you serve 125 days in the Jefferson County Jail. However, you would not be required to serve any more time in the Jefferson County Jail because you've already served 125 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you have spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Mr. Stanford, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Mr. Stanford, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Stanford, this will conclude your case. If you do not have anything else holding you in jail, you should be getting out of jail today. Mr. Stanford, please stand next to the bailiff. Follow his direction. Once you follow his direction, you can follow the bailiff and you have a blessed day. Okay, now, Mr. Washington, is the Spindletop still back there? Okay, we getting ready to go off the record on this here? Now, okay, this is cause number 23 CCCR 1934, case of Styles, State of Texas versus Donovan Travis Washington. Mr. Washington, is that your full name?
Sir.
Okay, Mr. Washington, how are you doing?
Good, and you?
I'm doing fine. Now, Mr. Washington, you're represented in your case by your attorney, Todd LeBlanc, who is appearing via Zoom. And Mr. LeBlanc, pursuant to Article 1.24 of the Texas Code of Criminal Procedure, all trials and proceedings shall be public. However, pursuant to the case of Lilly versus State 365 Southwest 3rd, 321, the right to a public trial is not absolute and may be outweighed by other competing interests, such as the interest of security, to ensure that the defendant get a fair trial and to prevent the disclosure of non-public information. Mr. LeBlanc, are you requesting that this portion of the hearing be closed to prevent the disclosure of non-public information?
I am, Your Honor.
Okay. The court finds that the party seeking the closure has an advance in interest that is likely to be prejudiced to his client. This request is no broader than necessary to protect the interests of his client. The court has considered other reasonable alternatives And so at this time, the court is gonna make these findings, and this court, this session will be closed to the